Sorry to interrupt. Everybody is having a great conversation from lunch and learning more from other people. But we have this next speaker who, as you could tell from the preview before lunch, is still full of energy and fully caffeinated and full of great information. And we've had Mark back here a number of times because the social media topic is one that's always changing and evolving. And I mentioned one case earlier, but there are employees that get fired over social media in the public sector. And interestingly, correct me if I'm wrong, Mark, in the private sector, your employer can say, no, you shall not and will not, and others will say, we might discipline you because you're not posted enough on it. But the private sector
at will employment
is different than the public sector. But Mark, and I'm not sure whether he mentioned earlier, he's a law director in one of the suburbs in Columbus, so he not only practices law but deals with the real issues that come up in municipal government as well as the other governments. So you know Mark, you know he's great, and he's going to keep your attention and keep you stimulated even when that lunch is digested. Now, I'll turn it over to Mike.
Your cookie.
But you get the cookie when you're done if you pay attention.
So, thanks for coming back. I would love to treat this the way Ani and I did this morning. I noticed Ani didn't come back, but don't say anything. This morning, and please, questions are appreciated, whether you want to do them through the little app or whether you want to raise your hand or interrupt me or whatever. We have the mics still available for you. So we are going to talk about social media. As my friend Lainey, you're going to hear a lot of it depends. And I'm not going to be able to give you a lot of definitive answers, which lawyers love, because then you got to call us and, well, it depends. Let's talk about the facts and let's see where this goes. But it is, of course, a serious topic. It is amazing to me when you stop and think about social media, how, and again, I'm not going to make the analogy that came in my head. I'm using my filter. But it is unbelievable how social media is so perfect for us idiot humans. I need instant gratification. Everybody wants to hear my opinion, of course, and I know what I'm talking about. And oh, by the way, if I've had a few beers, I'm even smarter. So, and we won't even talk about pictures. Okay, by show of hands, how many of you posted your lunch? No. Okay, thank you. So, but when it comes into the workplace, again, it becomes much more serious. Even if, you read this story in the newspaper, you would think it was funny, but when you got to deal with it, it's not funny. So, and a lot of what we're going to talk about here really implicates other laws as well, which is what makes it a little bit challenging. However, so again, look, we've got, you've all heard statistics about and by the way, just so you know, there's an outline with a lot more information in your materials there. So look at it now, later, or never, your choice. But again, 2 hours and 25 minutes on social media per day. Again, I'm starting to do the calculations in my head. What counts as social media? So my emails don't count, so I'm going to take that off the top. And it's not going any place. It's only going to become more prevalent and more easy for people to access social media, and that means more headaches for you in the HR world. However, I did find a solution to our social media problem. Let's see.
Then I thought, what if there was an app that could have warned my mom not to post the comment that got my dad fired? Wow. My app would predict the actual consequences of your online post before you hit send, protecting you from making mistakes you'll regret forever.
That is genius. But it's almost impossible to program the data acquisition, the AI. But with the right team of brilliant young coders...
I'm in! We're all in.
No, you're not. You're all terrible.
Okay, we've been coding for 97 hours straight, but we've finally got a build that's working.
Oh, I regret to inform you that my P-tube has become unattached.
Let's live test this thing. Who do we know with no filter and zero impulse control?
Say, Bart, look what we hacked from Skinner's hard drive.
Attention U.S. Patent Office. The following is video proof of the effectiveness of my laser nose hair trimmer. I'll just...
This is the holy fail. I've got to post a link with witty comment. World's lamest dork is giant loser. Poop emoji.
If you post this, you will receive a minimum 5 weeks detention.
5 weeks? I can't do a nickel. You know what? I'm not gonna post that video. Now to see if Conrad's prediction algorithm really works. But if you post it, I'll get...
5 weeks detention.
Oh.
So there you go. There's your answer. And, you know, it kind of cracks me up, the first thing that they said. What if there was an app that told us what the consequences would be? I think most of us can figure out what the consequences would be. We just don't care. That's, of course, not totally true because a lot of people don't figure that out. Oh, I'm astonished that that offended you, or that my employer might not like that. All right, so, but we got to talk about the First Amendment. So that's really where things start in terms of your regulation. As Chairman Casey said, you know, a private employer, you can get rid of anyone you want. It's so easy, as long as it's not because of their, you know, protected class, age, sex, race, disability, etc. But of course, with public employers, you have the Constitution that you have to deal with. So the first area is the First Amendment. Obviously, you cannot fire somebody for exercising their First Amendment rights. The government shall take no, I can't quote it verbatim, but the government can't do that. And you're the government in an employment context. So, but I think this quote makes a lot of sense. So the fact that expression may now occur in cyberspace, the vast democratic forums of the internet in general and social media in particular, does not mean that government regulation of that speech is beyond the reach of the First Amendment analysis and scrutiny. So as you'll see here in a minute, we're going to look at a 1987 case, which is still good law, which predates the internet, which is the standard that's applied to determine whether or not your employees have a First Amendment right to post something on social media, and therefore perhaps you cannot even discipline them for that. And again, this is the tricky area. This is where it gets into the depends and very specific analysis of the particular facts. So, again, I just mentioned that we have got this 1987 case, Pickering versus the school board of education. I can't remember what the Board of Education was, but I think it was in the Cincinnati area. And it's a U.S. Supreme Court decision. It basically said, and just real quick, the background is, you know, before this decision, you know, Mr. Pickering went before his school board, who he was a teacher for as well, and he lived in the district and complained about how money was being spent. And he was either disciplined or terminated as a result of that criticism. Now, I think we all understand, almost 40 years later now, that wow, I graduated from law school in 1987. Man, I'm old. That 40 years later, we understand that it's not that simple. So what Pickering tells us is that, first of all, a court has to determine whether or not the speech that got the employee in trouble touches on a matter of public concern as opposed to a private complaint or grievance. So a matter of public concern is very broad, and as you will see here, this should not be surprising to any of us, but when you stop and think about it, it might be, and that is a matter of public concern. It depends upon the subject matter that's being discussed and how it's being discussed. Well, it initially depends on the subject matter it's being discussed. It doesn't depend on the point of view. Chairman Casey mentioned this case from August 9th that was issued that I've thanked him multiple times for finding, because I did not see it. And I'm going to get into it here in a little bit, but it's somebody who has posted some things anti-Black Lives Matter, but as you'll see, that's a matter of public concern, regardless of your viewpoint necessarily. So first question, is it a matter of public concern? If the answer is no, then you can discipline the employee for it. I will also say this to you in general terms. If the employee is making an untruthful statement, you can discipline them for that too. The First Amendment does not protect untruthful statements. It could protect opinions that are exaggerated, but if somebody says that I'm the mayor of City X and Mark is stealing money, clearly that's a matter of public concern. If it is not true, that person can be disciplined for that statement. Obviously, there's a lot of hoops to jump through before you get there. If it is a matter of public concern, then there's a balancing test. The employee's free speech concerns or rights are balanced against the employer's needs for efficiency of operations and effectiveness of public service. And those cases come out all over the place, in my opinion, seemingly with similar facts. Now, again, if it's a matter of private concern, like there's a case that's cited in your outline, Connick v. Myers. It involved a deputy district attorney from, I think, New Orleans, who was circulating complaints or surveys around her office regarding the workload that each attorney was expected to maintain. The court and she ended up getting disciplined or terminated for that. Court determined that is a private grievance and not a matter of public concern. Now, I could see let's change those facts and say it's a children's services caseworker who's saying my caseload's way too high. I can't get to these kids who I'm supposed to help. That's much closer to a matter of public concern. The other thing is that when these statements are made off duty, I don't want to say there's a presumption, but there's more of a protection for those statements than if it's something that somebody is saying in the context of their actual job. Again, that's not the be-all and end-all, but that is a distinguishing factor that you should take into consideration if and when you're doing an investigation on these issues. And again, 1987 case, social media just simply makes it easier for somebody to exercise their First Amendment rights, which it probably is a good thing. There's case law that says, I know, I said probably. I didn't say definitely. It's a good thing if they say something that I agree with. That's the distinction. But there is a case, I'm not sure if it's in your outline or not, that held, and I think correctly so, that liking a post is a First Amendment exercise, a political post. If I like the post of a candidate for office, that is me exercising my First Amendment rights under the Constitution. All right, I have to go back and forth between different things, so I'm going to make sure I didn't miss anything. Sorry. So some of the factors to consider when you're dealing with the Pickering balancing test and you get to the balancing part, so it is a matter of public concern, but now we want to determine, is this enough to say the government interest outweighs the employee's rights? So some examples, it's not an exclusive list, are, does it impair the discipline by superiors or harmony among coworkers? Is there a detrimental impact on the close working relationships for which personal loyalty and confidence are necessary? So that standard might be different for different people depending upon where they are in the organization. Does it impede the performance of the speaker's duties or interfere with their regular operation of the enterprise? And the fourth factor listed in this particular case is, does it undermine the mission of the employer? So these are things that you and the folks you are working with are going to have to measure, by which you're going to have to measure whether or not discipline is appropriate as a result of a social media post or even a letter to the editor, frankly. So again, some other considerations to keep in mind, and I mentioned some of this. Here's the Connick v. Myers case that I mentioned earlier. And, again, as I said before, speaking of a private citizen is where courts are going to give the highest protection. But citizens who, and this is the quote that's here at the bottom of the slide, that being said, citizens who enter, and this is from a case law, this is not Mark Fischel, citizens who enter into government service must accept that there are limitations on their freedom, including limitations on the scope of their First Amendment rights. And look, all of you who have classified civil service employees working for your organization, we have this all the time. I mean, this is a good time to talk about some of this stuff, and we'll get to it here in a few minutes. But there are specific restrictions on certain partisan political activity that classified service employees may engage in. So they still can support a candidate, they can still give money to a candidate, they can't run for partisan office though and keep their job as a classified employee because again, the legislature, both at the federal level and the state level, have determined that this is the balance that we're going to strike because this is an example of one of those certain limitations, maybe not explicitly so, but referred to by the court in this particular case. So there are limitations, even as unfair as that might sound. And look, there are First Amendment legal limitations. There are also practical limitations. I think there are enough people in this room that I haven't heard me speak, so I'm going to use something that I've learned in law school that I've used in speaking all the time that would make your job so much easier if you can get the employees to do this. So if it was actually came from a law school professor who in law school, at least when I was in law school, like for most of your classes, the final was the entire grade. It's nuts. It took a lot of getting used to. So contracts was one of the first exams, and somebody asked the professor if he had any advice for the exam, and he was a deadpan kind of guy, and he stopped. Be smart, don't be dumb. So, and now if we only had an app that could tell us when we're smart and dumb, that would be great. But again, that's, so if you can convey that to your employees some way, that would be great. But in all seriousness, being smart means at least thinking twice before you post something that you're not sure about posting. I mean, at least think twice about posting something that, oh, look at this great meal I'm having today when you're off on sick leave. I mean, I wouldn't necessarily use that example, but that happens all the time, unfortunately. Again, that person's not being smart. Excuse me.
Mark, we got a question.
Oh, yeah, please.
Is an employee protected by First Amendment if they speak on details they learned because of their position, not as a private citizen?
Wait, say that part again?
Is an employee protected by First Amendment if they speak on details they learned because of their position, not as a private citizen?
That's a really interesting question because there's actually some case law on that goes both ways. So this slide here talks about Garcetti versus Sabalas. So whoever asked that question, it's perfect timing. In this Garcetti case, what happened was that Garcetti was the mayor of LA, Sabalas worked for the district attorney's office, or the law director's office, whatever they called it, and he wrote a memo in his official capacity and testified at trial for the defense based on the alleged insufficiency of the search warrant in a criminal case. And he ended up getting demoted as a result, arguably as a result of that. The city said there were other reasons, and the court noted that maybe there were other reasons, but because he learned of that information in the context of his official duties, and because he was testifying in his capacity as an assistant district attorney, that he did not have First Amendment protections for those statements. Now, there's some cases that kind of go the other direction. There's another case whose name is escaping me right now that had similar facts, except the court, and I don't think it was a Supreme Court decision, I think it was a Court of Appeals decision, the court said, no, because this employee made a public records request for this information that he knew existed because he helped prepare it, and then used it, that's protected by the First Amendment. I'm not sure, I don't understand that distinction really, except to think that maybe the Sabalas decision went a little too far, and that's reining it in a little bit. So the answer is no, in some cases there is not First Amendment protection. Now, Sabalas testified that I know that they covered up evidence. I think that would be a different story too. So I think some of it is factually driven. Hopefully I answered the question. Any other questions? Well, yeah, there's a hand here. Got a mic coming.
Is there a distinction between an employee or staff member who has been deputized and is then speaking as an extension of an elected official?
So the question is there a distinction between an employee who has been deputized and is therefore speaking or being perceived to speaking, I'm going to change it a little bit, as on behalf of the elected official. I don't think the deputized part matters. I do think, however, that if somebody is representing themselves as a representative of the government and speaking on behalf of the government and not in their official, in their personal capacity, there could be a distinction there. Again, some of it depends, on what the actual statement is, but I think there could be a distinction there. Right, they give an oath, right, but the oath also, again, the oath doesn't mean they'd lose their First Amendment rights. So I don't think it's just the oath. I think it's again, there's, as the lawyers in the room will understand this phrase, time, place, manner. The Supreme Court has consistently said you can have time, place, and manner restrictions placed on people's First Amendment rights. I think that's what that comes in. As Oliver Wendell Holmes' famous quote is, a person doesn't have the right to yell fire in a crowded theater, if there's not a fire, of course, because of the danger it causes. And I think that's a similar analysis to that. What's the time, place, and manner of those comments being made? Is that person going up and calling a press conference unbeknownst to the management employees and doing it right outside the building or in the conference room or something? That would be a lot worse than if they're posting something on their video on TikTok or something, saying something. And again, I think it depends. Mike, look at that efficiency. These guys are good.
Thank you. Would the same hold true, in your opinion, when an individual, through their social network, whatever channel that may be that they're using at that particular time, if they're sharing the personal opinion, but they, on their social media platform, they identify as ex-employee of ex-employer, and is there a nexus strong enough that whether that First Amendment right would pass or fail there?
That's a really good question, because I think the answer is yes, it does matter. Again, some of it depends on what the context and the content of the speech is, but one of the things you want to know, and this is outlined in the outline later on, but it's a perfect time to talk about it. When you're doing an investigation into social media allegations of somebody doing something bad or stupid on social media, one of your employees, one of the things you want to look at is, does that Facebook site or whatever, fill in the blank of the more recent ones, whatever they are, identify that person as an employee of this organization? Does it have pictures of them in their uniform if it's law enforcement? Things like that. I mean, again, I've told this story before too, so I apologize to those who have heard it, and this is an extreme example, but back in the day of, oh my God, I just lost it. One of the earlier ones before Facebook that doesn't exist anymore. MySpace, that's it. Yes, thank you. I had it, lost it. A county children's services employee went on MySpace and was bragging about how hot she is and how good looking she is and how, nothing over the top, maybe something that we wouldn't post, but nothing that would get you in trouble. And oh, by the way, you better be nice to me because I am a caseworker for blank county children's services and I can take your kid. That's a better, those are better facts than just I posted where I work, but that is a factor, absolutely. And look, I want to make sure I touch on this, and so I'll do it now. When you're doing an investigation regarding social media, even if it's a private page and somebody comes to you, ask them to take a screenshot of it. You're allowed to do that, even if it's a private post and somebody's sharing it with you. Also, or if you come across it, take a screenshot of it, because obviously those posts go away. The second part of it is take a screenshot of their profile, especially if they've listed themselves as an employee of X, of your organization. All right, there and then there.
So to piggyback off of what she was saying, obviously we can't, I guess, totally censure what somebody does on their personal page, but if a person made a political type of statement, they had a feeling, and it's on their personal, and yes, she does have her company logo and everything on there. Does it matter if it's done on work time? Can anything be done because it was during work, or are we crossing a line where, well, did she do it on break? Did she do it on lunch? Is there any repercussions to anything like that?
So first thing is, your policy, and again, this is in the outline under our section of tips, should absolutely prohibit a person on their personal page from using your logo or any insignia of your organization, period, end of story. Again, it's just being smart, but you got to have a rule that says that, so people, because not everyone's smart, or thinks like that, I should say. It's not fair to say not everyone's smart. The second part of it is, yes, I think it does matter if it's done on duty versus on my personal time. And you can have a policy that says you shall not do your own personal social media on employer time. And again, proving that is a little harder sometimes because I'm on break. But I think you can have a policy, and even if you don't have a policy, I think it does matter that there's maybe slightly less protection under the First Amendment if I'm doing it while my employer is paying me. Yes?
So what happens?
It's on.
So what happens if an organization has a social media policy for employees and it's an administrator or the employer that violates and represents himself as a representative of the organization and goes out in public and violates their own policy?
So I think two main things come to mind. One is they should be disciplined. I know that's easier said than done. And two, it's going to be a heck of a lot harder to discipline the next employee who comes along when they've done that. So again, that is very problematic. You know, it's do as I say, not as I do, which is a ridiculous way, an inappropriate way to manage. But I think those are the answers. I think the first part of the answer is probably less realistic that that's going to happen. The second part of the answer, it's going to benefit the members that you represent if and when the employer tries to discipline somebody for doing something similar and the administrator or the supervisor got away with it. And that's true whether it's social media or anything else. So, okay, so we talked about Pickering. I mentioned this earlier. Partisan political speech this is a comment or section that, of course, applies to social media, but also beyond just social media. And I didn't take the time to list out what are the examples of what employees can do and cannot do, but on page 3 and 4 of your outline, there are 9 things that are listed under 124.57. They're not in the statute, but they derive from it, are things that generally conduct permitted for classified employees: registering and voting, expressing opinions, attending political rallies, signing nominating petitions, displaying political materials at an employee's home or on their property, wearing political badges, not necessarily in the workplace, serving as a precinct official. And again, I'm just mentioning some of these. Some of the things you can't do: you can't be as a classified employee, you cannot be a candidate for partisan election in Ohio. Again, that means township trustees fine. Some nonpartisan city or village councils would be fine. School board can be fine, assuming there's not a time or other ethical conflict. But understand that at least the folks at the back will tell us if we're right or wrong eventually if a case gets to them. My interpretation of that means that the minute somebody starts circulating a petition for themselves or letting others circulate a petition for a partisan political office, they have violated 124.57. They don't get to just, I'll see what happens. Nope, they haven't violated 124.57, and they can either be told to stop or you're fired, in my view. Again, treating people similarly. You can't say, I like your political party, so go ahead. That will get you in trouble under the First Amendment, and I think you guys all understand that. So again, that's listed here. Generally speaking, it's unusual to find things violating 124.57 partisan political activity appearing on social media, because usually it's opinions and things like that may or may not be protected by the First Amendment, but don't violate partisan political activity prohibitions. Before we get to the Fourth Amendment discussion, I want to talk about this case that we've been alluding to that was just issued by the Sixth Circuit Court of Appeals on August 9th. It's Noble versus the Cincinnati and Hamilton County Public Library. And the Sixth Circuit, as if you don't know, is the federal court of appeals that has jurisdiction and makes the law for us in Ohio as well as Michigan, Tennessee, and Kentucky. So it's the law of the land, and it's not in the outline or on the PowerPoint. So I want to hopefully get a little participation here because I'd like to see what you think when I tell you some of the facts. So Mr. Noble was a security guard at Cincinnati Library. Do you know this case? I'm trying to pull up Cincinnati area. Okay, so you've read about it. Yeah. So that's part of the issue. Yeah. Don't know if you pull it up, then you can't answer any of the questions. Okay. All right. And so Mr. Noble posted on Facebook let's see, he has a friends-only Facebook page, less than 100 friends who could see this posting. And the meme was, I wish I had thought of this in advance to show it to you, because it's pretty offensive. Instead of all lives matter or Black Lives Matter, it says all lives splatter. Nobody cares about your protest, with a car and kind of stick figures of people falling over. So, first question is, who thinks that would be touching upon a matter of public concern? I don't have a fancy poll thing. Who thinks it's not touching on a matter of public concern? I think he can do it. I think he's allowed to. Yeah, the court said it touches on a matter of public concern because, again, what the court said is that, look, a lot of library employees were talking about this stuff. The library even posted on its website support for the Black Lives Matter movement. So the subject matter touches upon a matter of public concern. He also, I love this part of the case. I'm guessing he's kind of a young guy. He said, wait, I got to find the actual quote here. Damn it. Sorry. So anyway, when I find the quote, I'll read it to you. But the post was up for less than 24 hours, and the case points out he took it down at the recommendation of his mother. So I love that. That's smart. That's good mothering. I could see me having to do that with one of my kids, perhaps. Maybe not anymore. And there's no. So then the court goes, and the facts are: there's no evidence that anyone outside the library ever saw the post. There's no proof in the record that he ever did anything at his job, either before or after the unfortunate post, to cause trouble with his coworkers or library patrons. The library. So first of all, and the post came again. Nothing's private on the internet. Even though he had a small group, some employees at the library became aware of this post and shared it with their managers or the HR person. And so I guess my question is, does this, in your mind, does it merit an investigation? Anyone? I see a head shaking yes. Anybody think no? I say no. No? Why you say no? Sorry, we got to get you a microphone, otherwise I'll get in trouble. Here. Oh, you got one right there. I always say that too, and they doubt me.
I just said no because I think he's allowed to.
Okay.
Says right.
So you wouldn't even investigate it just because, and again, I'm not saying you're wrong, I'm just trying to understand it, that I'm not asking you if he should be disciplined, I'm asking, should it be investigated? And again, stick to your guns, I'm not saying you're wrong.
My law director would say no.
There you go. And again, so if you choose not to investigate it, I think in that case, you do need to let the other employees know why. Because some people did bring that to your attention. So I think that's good practice. Again, I'm not saying you have to investigate this every time somebody comes with you about a complaint, although again, this one, as you'll see, did get investigated. I think it's probably safest to investigate, even if your conclusion is no discipline is warranted. So the library did conduct an investigation, and they concluded that he violated the workplace harassment policy, which he had signed, requiring that employees maintain a working environment that encourages mutual respect, promotes civil and congenial relationships among staff members, and is free from all forms of harassment. But prior to that post, nobody had ever complained about him. They had no concerns about him whatsoever. So, I guess, well, let me make sure that I'm not just holding some facts back on you before I ask my question. The court did indicate that there's no evidence that Noble, the employee, literally wanted lives to splatter or a vehicle to run over any protester. He maintained that the meme conveyed only hyperbole, albeit a highly offensive message. And again, as I said before, the court points out that during the Black Lives Matter the height of the movement, short after the George Floyd murder, that the library again showed its support for that movement in tangible, outward ways. And of course, some of the employees of the library also did on their own personal social media. So, who's terminating Mr. Noble? Who's not terminating? You're not terminating. You already said that. You already stuck your neck out. Who's not terminating him? I got hands not terminating. Anybody want to share their reasoning why? Here, I got some. Oh.
I don't need a microphone. I'll talk louder. But my reasoning behind it is just because the library promotes a stance on a political issue doesn't mean necessarily in my personal life I have to support that issue. I can have a disagreement with that as long as I'm not representing myself as a Cincinnati or any public employee of an organization. I'm entitled to my political or my belief, and whether they be offensive or not is really, and I'm sure it's been identified by the court, is really a subjective opinion.
Oh, it's yeah.
It's the same thing because you said the library employer cited the workplace respect.
It was working for everyone but you.
Just pulled out our agreement, and we have a provision within our agreement that says the board, the superintendent, and the association can best carry out their respective responsibilities in an atmosphere of understanding and mutual respect. So who determines that?
Well,
that's a slippery slope, I think.
Sure. In the first instance, the employer determines that, reviewed by an arbitrator of the State Personnel Board of Review or a court. So, right. I mean, some of it's your best guess. So we heard the no. Would anybody fire him? I don't believe that. Some of you would fire him. I think I probably would have before I read the decision and understood it, because here's the other thing. Oh, is there a hand there? Oh, I'm sorry.
Now he's up to who would keep or who would fire the guy. So I'm just interested in wondering.
Can you hold it closer?
I'm just interested in wondering if anyone else believes that it's alarming. Because what's the difference between what you described and the same scenario that we've witnessed, unfortunately, with the schools when someone has come in and they've killed children or what have you. But they have found that in the past they have pictures of shooting people or guns. Is that not the same?
So again, I think that's a really good point, and I think that's right, because I think it's easy for us to sit here and read this case and talk in this relatively sterile environment about you. Oh yeah. So the question, I'm sorry, was about, well, how is that different than if you have a kid posting a bunch of stuff that he's going to shoot up the school, and here he's posting. Again, you can't see the meme, but it's showing people falling down and flying around shortly after Charlottesville, which of course involved somebody dying because of that. So how is that different from the schools when you have a kid posting, I'm going to shoot up the schools, and you don't do anything about that, and you just let it go? And again, I'm not saying, obviously there's an investigation here. Most of you said you would investigate. And I think that's a valid consideration. And that's where an employer, I think, really needs to, because what you said is absolutely right. Why should we get to decide? But there are also practical considerations. Now, with Mr. Noble, there was no evidence. He drove for work, but he didn't really drive for work. There was no evidence that he could have carried that out when he's working for the library, because again, he didn't drive for the library. So I think that is a little bit of a distinction. But going back to your point here, and again, don't mean to pick on you, but there's another case in the outline involving an employee, I think of the Cleveland, it might have been Cleveland EMS, who posted online that he wished he was the one who killed Tamir Rice. Now, this is an EMS guy. This is a paramedic. is that different than a library security officer? And where do you draw the line? The court found that termination was appropriate in that situation. And again, I think there's a difference between the overt statement and this offensive meme in this particular case. Again, but if that meme, if that meme, and it does not, but if that meme showed, they're just white stick figures. If that meme showed black people being thrown all over the place, are we looking at it differently? I mean, I think so. I think it might be a different outcome. So again, that's why I keep saying it depends. I mean, maybe it shouldn't be a different outcome, but I think it has a different message then. And look, a lot of this, I think, is, from an employer standpoint, a lot of times the employer takes the position, and maybe rightfully so, not this flippant as I'm going to say it, but you know what? We're better off firing him anyway, because let somebody else tell us we were wrong instead of, God forbid, he does something like this meme suggests, or instead of us getting the backlash for it. So again, I can't say those are not valid considerations. In the public sector especially, that political aspect, small p political aspect, cannot be ignored in my view. Yeah?
I just want to throw this in there. Say the next day he decides he's going to post accidents that happen, around race cars. And he actually has a video of somebody, one of the fans and spectators that probably most of us have seen if we've watched any type of those road course racing, which is absolutely nuts to me. But he shows one of those wrecks happen where people get hit. What stops the employer then from going down that slope of saying, now I'm connecting this to this and that to that, which really, you know what I'm saying?
Right. But if the employer is lying,
you can't fix stupid. You can't.
Right. That's right. And if you could be fired for being stupid, a lot of us would lose our jobs. Josh, you got somebody.
I think you can fix a lot of that on a situation. The first situation, he should have just been put on final. Had a stern talk about professionalism, what our expectations are. I don't think, as you said, that it rose to the facts of being terminated. That said, if you have a situation like we're talking about there, then all of a sudden you've repeated actions and you've had a pattern of behavior that puts you in a situation where I can say, we put you on final for this and now you've done it again. And now we have a paper trail that shows that we've taken the proper steps to make sure that this term is going to stick and we're not going, actions of us have to pay him less. Because I understand your situation where you say, it might be worth it just to fire him. Is it worth it to lose the money? Or is it worth it to, hey, I know we're employing oil, all of those things, but will it cost us money in the long run? Does it help with our employee morale? All of those things we have to take into consideration when we decide we're just going to willy-nilly term someone.
Well, you do have to take that into consideration. The library would tell you that they did take that into consideration by concluding that he would have it would have undermined the morale at the library due to those posts. Again, I think it's but I agree with you what you're saying. I'm just saying with the libraries, their thought process. I think it would be different if he posted that meme and said, and by the way, I have a car that I drive for work, so watch out. I think that's probably a different situation. Here's what the court said. So the court said a couple things that I think are instructive. And it was a 2-to-1 decision. And all these 3 judges were appointed by Republican presidents. So you can't say, oh, this person was just a liberal or this person was just a conservative. They all come from a similar background for what that's worth. I think the best lesson you take away from this is that you never know what's going to happen when you get to court, which is why a lot of cases settle. But first of all, the court noted that the library fired Noble for a post made on his private Facebook page while he was at home and not working, which raises more First Amendment flags, like I referred to earlier. There's no evidence that Noble took his politics to work or that his views on Black Lives Matter protests or any other political matter ever interfered with how he performed his job. To put this in and then they go on to talk about an older case And the court then said, we determined that the scope of the library's interest by considering whether Noble's speech, 1, impairs discipline by superiors or harmony among other coworkers, 2, has a detrimental impact on close working relationships, 3, impedes the performance of his ability to perform his job duties, or 4, undermines the missions, that those factors are not outweighed by his right to make a statement involving a matter of public concern. So this is a kind of a good recent roadmap of some of the factors that a court will look at with, again, back when that happened, I could easily see myself going along or advising a client to terminate in the context of when it happened and the time that it happened, even though 4 years later the court says no. And again, I understand why the court says no, although, like I said before, the court had, let's see. Oh, I'm sorry, but one other thing I want to mention here is, but the court did note that, again, his speech was highly distasteful, but the First Amendment protects abhorrent speech and does so even if the speech makes others feel uncomfortable. A public employer need not wait until an actual disruption to discipline by an employee. It just needed to be something more imminent or more tied to his behavior or ability to get in the way of things. And they, again, refer to a spotless record. So that was a big factor. But again, there's a dissent that from the chief judge of the Sixth Circuit Court of Appeals who said, nope, I think termination is appropriate in this situation. Gotta find the mother of quote. It was so good. Oh, you pulled it up already for me? Man, oh man. Anyway, it was pretty good. It was like, and he was a good boy and listened to his mom almost, not quite those words, but pretty close. Anybody else any comments or thoughts on that? I mean, again, yeah, got several here as the microphone's coming over. Again, this just shows you, and I think you already understand it, but shows you the challenges you're dealing with and how things aren't so clear-cut, and that's going to challenge for you in the HR world to make sure that the people who make those final decisions on termination or discipline understand the risks associated with this. Yes?
Okay, there's two things that I'm looking at, because I pulled up the case, right?
My God, that's another problem.
Seen the whole opinion.
Phone's off.
No, never. Too late. I got an email from my library group like 6 weeks ago.
Okay.
Because they were like, hey, you might want to think about this in the future. Here's the point where I think this case might be a problem.
Go ahead.
Because this is protected speech only by the widest of fanciful margins, because it's an endorsement of violent action against a specific group of people. That's insane.
I am not here to argue with you on that point.
I do not understand it at all. I would probably take the hit for it. Like, I could not permit a person who endorsed a call to violence against a specific group of people to continue to work with the people who have avowed that they belong to the specific group he has endorsed violence against.
And the court did make clear.
And they are immediately going to turn to me and go, where are my worker protections from this insane person?
And two points, and I don't disagree with anything you're saying. Point number one is that the court did state that some people, library employees, had attended Black Lives Matter rallies. Number two is, though, to the contrary, I think what the court said is that, but there's absolutely no evidence that he was predisposed to doing any. These are my words. I think that's one of the ways the court came down, on his clean record and no evidence that there was an actual detriment. But to your point, what, do we have to wait till somebody gets hurt? Yeah, I understand.
I would not be surprised if this occurred in my library system. That's what I do. I run a library system.
Yeah.
If an entire group of employees, and it doesn't have to be this political in nature. It is completely divorced from support or dissent against Black Lives Matter as a movement. If I have a group of employees who are being told that someone they work with endorses violence against them because of their membership into a community, I am going to have a group of employees who refuse to go into the parking lot when he is near his own vehicle.
And if they had had those facts, then I think the case might come out different. But no, I understand what you're saying. It is a tough call. At least I think it's a tough call. And like I said, I probably would have advised a client to terminate him in 2020 when this came up.
I would do it now.
I understand what you're saying.
There's
Again,
absolutely
it's,
no way.
yeah, and it's a slippery slope too if you don't. Got hand behind you. Oh,
I have a mic. One of the things that I have found that is most difficult is employees fail to understand how a meme or some type of like picture conveys the same thing as words. Like if they simply like wrote those words out, my staff would be like, "Oh no, that's bad."
That's a really good point.
But the fact that it was a meme, they think it's okay. Like everybody should know this is just a joke. And that's where I feel like we're having difficulty. Obviously, it's an education matter, but we're still having difficulty going, no, that's still not okay.
and I think that is a really good potential training tool for when you do any training on this, to steal that idea and say, okay, here's a meme. I know you have to be careful how offensive you're going to be in the training. Here's a meme. Is anybody bothered? No, it's just a picture. Here are the words, or maybe you start with the words and then show the meme, because you're absolutely right. Just like a meme is protected by the First Amendment potentially, it also conveys that message the same as the words would. I think that's a really interesting point. Yeah.
I guess my question, without having seen the case, was the termination based on the social media policy, or were there other policies invoked, like a workplace? Because I would think we would recommend this being looked at from a workplace violence and perhaps proceed. You know, we're a municipality. We have a police department to go from that perspective in the investigation,
right?
As opposed to just, hey, you violated our social media policy, so we're terminating you under that.
No, they terminated him largely because of his violation of the workplace harassment policy, which required employees maintain a working environment that encourages mutual respect, promotes civil and congenial relationships among staff members, and is free from all forms of harassment and violence. I think this case also is really interesting because it does put most, if not all of us, in a very uncomfortable position, because it is speech that none of us would say is okay. We're not okay with this. But again, the First Amendment is about protecting speech that we're okay with and that we're not okay with. And I think that's the discomfort I have with this decision, and the two things going back and forth in my mind.
To kind of piggyback on what the gentleman was saying over there, that was my first thought. This way, he violated an employer's policy, the social media policy. So, but I've heard nothing about progressive discipline. He's never been in trouble before.
Right.
So how did it even get to the point of termination when, and maybe, that's where I'm kind of confused. Like, okay, I'm thinking you violated our social media policy. We're going right into progressive discipline. First is first, you never, verbal, written, then if you do something like that, we're progressing. But so, it seemed like they just went straight to termination.
Yeah, and so I don't know the answer to the question of what they were thinking, but I think it comes back to this comment over here. I'm not taking the chance of letting this guy continue to work as a security guard when he's espousing these views. I also think that the way the court wrote its decision, it didn't say termination was inappropriate. It said discipline was not appropriate. Now, I think as a practical matter, well, I take that back. They were looking at termination, of course. I think as a practical matter, if it had been a reprimand, we would have never had this case, because he would have taken his lumps and moved on, and if he did it again, he could easier to fire him. Right. So that's a really good point. Got a hand there. Man, I hope you guys have your, whatever, count your steps in your pocket and get credit for all this stuff.
Can you explain to us the difference between this case and the Cleveland EMS case? Because if I remember right, the federal judge in his decision talked about the city of Cleveland being able to protect their image and then the citizens losing faith in the EMS program by the words that guy said.
So I think there are a couple of distinctions, and again, there's a blurb to the case in the outline, a small, very small excerpt. But I think there are a couple of distinctions, especially in hindsight. I think one distinction, again, despite the comment or the very good comment that we heard about, it's different if it's a meme versus it's. I think the fact he said, "I wish I was the one who shot Tamir Rice," is just. And I also think the fact that this employee's job is to save lives, that the city of Cleveland was justified in saying, in that situation, you don't get a second chance. Are you going to show up at a scene where a 13-year-old boy is, of color or not, is shot and you think it's okay, so you're not going to do your job? I think those are the distinctions. I also think, again, this is totally my opinion. I'm not basing this on anything in the cases. I think that the pendulum goes this way and the pendulum goes that way. Don't get me wrong. The EMS case would come out the same, I think, today as it did back then. Again, mostly because of the nature of the job.
Got a question from earlier. It says, in an earlier slide, it said that an employee's dispute with their employer is not of public concern. But if an employee makes a social media post about a dispute with the employer about pay and several other employees chime in, even if it is not protected by the First Amendment, wouldn't you still have to assess whether it constitutes protective concerted activity about a term and condition of employment? The First Amendment isn't the only analysis that needs to be considered for social media posts. Is that correct?
That's correct. So I'm guessing that came from one of the folks who represent unions in this room, not necessarily, because that's a very good point. And not a point that employers, especially public employers, necessarily think about. So the comment or the question was, okay, so we're talking about the First Amendment, but we also have to talk about what's known as A8 rights under federal law and some section under 4117, which I should know better than federal law, but I don't off the top of my head, that say that employees have the right to form a union or not form a union, but they also have the right to engage in concerted activity for their mutual benefit. I'm paraphrasing that a little bit. So the National Labor Relations Board has decided cases and issued rulings that say that, for example, a policy that a private employer has that says you shall not criticize the employer on social media violates that protection under federal labor law because the employees could be engaging in concerted activity for the benefit of them and their coworkers. What I will tell you is that that case law is somewhat developed in the federal side of things, dealing with private employers. There's nothing in Ohio with the State Employment Relations Board that I'm aware of that has gone there yet. But it is something to keep in mind. Again, probably a topic that maybe getting in a little more to the weeds on that, which I'll try to avoid since, look, I love the questions. We're also at, you guys, go ahead.
I was just wondering if you could give a couple examples of things that we, as HR professionals, have brought to our attention should stop immediately and that would be disciplinable.
I'm sorry, I missed that last part. We should stop immediately and what?
And might be disciplinable. You're giving us the examples of what's not. Can you give us examples of what is?
Sure, I can give you some easy examples. Disclosure of confidential information, disclosure of representing themselves as speaking on behalf of the organization when they don't have the authority to do so. I can give you examples of, again, anything that is reasonably perceived, and I know this Noble case throws us into a little bit of a tizzy, anything that's reasonably perceived as a threat, anything that would actually have a likelihood, or a reasonable likelihood, I'd say, of undermining the employee's ability to do their job. So again, going back to that, there's cases that talk about a police officer who goes on social media and either uses the worst of worst racial epithets, or even something short of that. There's now a legitimate question of whether that person will fairly and appropriately enforce the law. So I think that's another example. And I will contrast that with a case involving I think Charlotte, North Carolina, involving a non-safety dispatcher, a dispatcher who sat in his office and took calls of sewer and public works complaints, and then dispatched a crew. He was the local poobah, grand poobah of the KKK, and it was in the paper. And in that case, the court said, no, you can't fire him because it doesn't have an impact on his ability to do his job like maybe an actual safety dispatcher would. So those are some examples. Again, there's actually plenty of examples, and it's just more interesting to talk about the ones where it kind of goes haywire a little bit. Other questions or thoughts? I really appreciate the questions. I want to talk a little bit about the Fourth Amendment, because the Fourth Amendment is something else you have to be concerned about when you're dealing with social media investigations. As I said before, you have every right to say to an employee who's coming to you and said, hey, Mary's posting that she's in Mexico when she's off on FMLA leave. There's an actual real case about that I've not only did the Mary or whatever her name post that, she also then sent an email to her to her boss, expressing how upset she was that nobody reached out to her to see how she was doing. And the supervisor sent an email back and said, well, we thought that since you could go to Mexico, ride on a jet ski and drink, that you were okay and you'd be back to work soon. She ended up getting fired. But make sure you get that screenshots. Again, like I said before, that's not a violation of the Fourth Amendment. What is a violation of the Fourth Amendment is pretending you're somebody else and you want to friend them and so you can do an investigation. That's a problem. It's not a problem if you ask the supervisor who is friends with her, say, hey, I think she just posted some stuff. Can you go in and look? That's okay, because again, she has access to that. So, and I shouldn't have to tell people not to misidentify folks yourself when you're going on social media, but guess what? It happens all the time. By the way, that's another really important thing in your investigation. Make sure it's a legitimate post. I mean, I don't know how to do all this AI stuff, but obviously a lot of people do, since I think Taylor Swift endorsed Trump. I'm sure that was news to her, but at the same time, it's on the social media stuff, so it must be true. So a couple other Fourth Amendment things. In your policy, you should make it clear that employees have no reasonable expectation of privacy when they're using your computer, your phone, any of that stuff. It's all subject to your search. You can, as I said before, have a policy that says you don't do any social media while you're on the clock. And it's harder to enforce, but if you catch somebody doing it, then you can discipline them. You also want to be careful about, I just lost my train of something else I was going to say. There's also this idea here, let me flip the slides here. Whoops, wrong way. You also want to be careful, so when you're dealing with these issues, you've got this, talked about the reasonable expectation of privacy, but there's also this idea of the scope of the investigation. So from a Fourth Amendment standpoint, again, the Fourth Amendment prohibits the government from engaging in any unreasonable searches and seizures, which would apply to you in these contexts in a disciplinary investigation. So the question is, when you're doing an investigation, why are you investigating it? At the inception, what are you looking for? Now, I'm not saying you can't expand that if the facts take you there, but don't ask for this or look at this when it could just be this, because you might find things that you're not allowed to know because, again, maybe there is a reasonable expectation of privacy in that situation. So again, here's some things to think about. I mean, some reasons why, I think pretty obvious reasons, but reasons why you want to prohibit social media use while people are on the clock. I guess I have a little more time than I thought. There are also some. So actually, I want to mention a case for what it's worth. If you want to look at it later, it's on page 6 of your outline. But it involves a case where the ACLU took up some police officers' complaint against the city of Memphis, who was looking at personal cell phones, and how far they could go in reviewing these personal cell phones. And again, the city fell on the right side of things because the officers were using their cell phones for personal and work reasons, and the city limited what they were actually looking for in the context of their investigation, and didn't just say, oh, let's look at everybody's search history for the last 14 years or whatever might be involved. And another point to make, if you're going to let employees, and again, if employees are going to use a personal device for work-related things, please make sure they understand that there are public records obligations that they have. This is outside of social media. But so if an employee is using a Gmail account of their own personal Gmail account on their phone to send work-related emails that would otherwise be a public record, that email is a public record. Same with text messages. And employees need to be screenshotting them, and you or your employer needs to be preserving those consistent with your records retention schedule. That can become very problematic. Question, mic's coming your way. I'm just following the rules.
Is there a distinction between, is it the device, or now through Verizon or AT&T, you can have two lines on one phone? Can you make the distinction that one line is for professional business and one is for personal?
I guess you can. The question is whether or not you used, the distinction is based, or the decision is based on the content of the information, not on if it's personal or business. But yeah, if you have one phone with two lines and you never use the personal line, then there's no issue.
Okay.
Or shouldn't be. Again, we've talked about this in general terms, but of course an employer has the right to regulate and respond to off-duty social media use. But again, we talked about the fact that there's far greater protections. There are also protections under the 14th Amendment to the Constitution, which basically guarantees everyone due process, and what flows from that are a lot of non-discrimination requirements. If you end up on someone's social media account, whether it's because you're doing a background investigation pre-employment or something like that, there are things you may come across that you are absolutely prohibited from considering about when you hire them. And there are things that you would never ask them in an interview, like, do you belong to any political groups? Well, you might find that they do. And again, I'm not saying that it's illegal for you to know, but it's easier for that employee who doesn't get hired to say, hey, you did it because I'm affiliated with this political group. A disabilities rights group, you might find out they have a disability that you don't otherwise know about. Again, I'm not saying not to do it, I'm saying be careful. And some of the best advice would be, if you have the ability to do this, is have somebody outside of the process review, not a decision maker, review their social media use to make sure there's not legitimate things you can consider, like, yeah, I just got fired and I'm suing the last employer and they didn't disclose that to you, or something else, which, we can all imagine an employee doing. Can you ask for passwords? No, you cannot. Now, there are actually, in Ohio, there's no law that specifically prohibits an employer from asking for passwords. I am not comfortable if a public employer is asking an employee or requiring an employee to give them their password, because it's private and designed to be private. So I would say no, I do not believe. There are some states that's explicitly prohibited. Thought I had before it came back to me is that, so again, I don't need a show of hands, but how many of you or how many of your managers or supervisors are friends with coworkers and subordinate employees on social media? If you are, that's fine. But if you are, please understand that a social media post that might be can trigger your obligation or a supervisor's obligation to take action to investigate allegations. It would be, if you find out that, so again, I think best practice is don't do it. I'm not telling you it's illegal or immoral or totally improper, but it may not be the smartest thing to do. Because if you find out that a subordinate is complaining about sexual harassment or what she believes sexual harassment in the workplace, or if you find out that somebody, is, been off work for some medical reason that you weren't aware of, that might kick in your FMLA obligations. It will kick in your FMLA obligations. And it will kick in your obligations to investigate an allegation of sexual harassment in my example. So again, maybe that's another best practice to think about. I want to, I've talked a lot about things that are already in the outline. There's actually on page 12 a case dealing with, it's out of New Jersey, but it deals with the issue of fraudulent ways to get a hold of people's social media information. I guess in the last couple minutes, I just want to mention a couple things that are on page 13 of the outline. So social media investigations. First of all, when you're doing an investigation, have the person you're investigating identify their account, making sure that it's their account. Again, if they're lying about it, that's going to require you to investigate a little bit more. Ask them to explain their post and why they made it. Again, maybe you want to get that insight. I know that might implicate First Amendment issues, but that's part of the investigation. Confirm and find out whether their page was public or private. Again, as I said before, ask them if you don't have access to it, does it identify you as an employee of this agency? So there's a couple of things to keep in mind. Again, I guess the last thing I'm going to talk about really quickly is, but I would suggest that you or folks in your organization take a look at this, is the question, and there's some recent case law on it too. It's on page 15 and 16 of the outline. The public employer's own social media page. When a public employer decides, or a public entity decides they're going to have a social media page, the First Amendment applies to that. So you have to decide, are you going to allow comments on that page? If you allow comments, then you can have rules that say, okay, you can't use profane language or vulgar language or something like that, but you can't be deleting people's comments who don't agree with your position. That violates the First Amendment. I think best practices is, and I know that the politicians will, and I don't mean that in a bad way, they will say, no, we don't want to do this. The best practice is to not allow comments on social media pages. It's for information purposes only. Otherwise, you might fall down regarding the First Amendment. All right. What does it say?
It says he had the reason, the good sense to...
apparently because his mother asked him to take down the post, to do so, and he had the good sense to listen to her. I love it. Thank you. It's true. Listen to your mom. All right, I'm done. I'm going to be around. I'll be happy to answer questions. Thanks for your participation.